Mr. Hitchcock.
May it please your Ladyship, I appear for the Appellant Hippodrome Casino with my learned friend Mr. McGee and my learned Mr. Donwell appearing for His Majesty's Revenue and Customs. As you'll be aware, the Appellant Casino is what's termed a partially exempt trader. That is, it makes both supplies which are subject to VAT, such as its sales of food, drink, theatre admission, as well as those which are exempt in the form of its exempt supplies of gaming. The input VAT that it pays on expenditure that's directly attributable to its taxable and exempt supplies causes no difficulty. It's either recoverable or not, as the case may be. But in the case of input VAT on expenditure that relates to its business as a whole, often referred to as overhead VAT, such as the VAT it pays on its rent, the position isn't quite so straightforward. The input VAT on that expenditure has to be apportioned in a way that reflects its use. And it's the means of such apportionment that lies at the heart of this appeal. In particular, whether the appellant was required by Regulation 107 B of the 1995 VAT Regulations to apply a method of apportionment other than the default or standard turnover-based means of apportionment, a means of apportionment prescribed by Regulation 101 of those 1995 VAT Regulations, as the FTT held. And the Upper Tribunal, of course, disagreed, and it found that it was able to overturn the decision of the First Tier Tribunal and remake it on the grounds that the FTT had failed to explain the basis for its conclusion and for having rejected my learned friend's submissions to the contrary. And in doing so, we contend that the Upper Tribunal erred in law, our first ground of appeal, which we develop at paragraphs 11 to 33 of our skeleton argument. But even if we're wrong, it doesn't follow that this appeal should simply be dismissed. There's a further significant error, we contend, on the part of the Upper Tribunal in the approach that it then adopted when it went about remaking the decision of the First Tier Tribunal. In framing the issue before it, the Upper Tribunal found that irrespective of any deficiency with the standard method as a reliable proxy, it should nevertheless continue to apply unless the taxpayer was able to identify a proxy for the use of its VAT-bearing overheads that was more reliable. And in doing so, we contend that the Upper Tribunal misconstrued Regulation 107B of the 1995 regs, and thereby misdirected itself. Our second ground of appeal, which we address at paragraphs 34 to 48 of our skeleton, before then addressing the consequences of that misdirection at paragraphs 49 to 57.
So what's the actual misdirection?
The misdirection that forms the second ground of appeal is that the question the Upper Tribunal asked itself was, is the override calculation that's been proposed by the taxpayer, is that a more reliable proxy for the use of the taxpayer's overhead costs than the standard method? And we say it rather puts the cart before the horse. What it should have asked, in accordance with the plain language of the regulation, the first question is, does the standard method represent a fair and reasonable proxy for use? And if not, then let's go on to look at the override calculation and alternatives. So it got it back to front, if you will, and that's the misdirection, my lady.
So it should have looked at the standard method first to ask itself whether that represented a fair and reasonable method.
Absolutely.
That's your case.
Absolutely.
Yeah, I had understood that.
And as I'll show you when we get to this, we'll see that there's parallel legislation that applies in the case where traders has adopted a special method, called the special method override. And the approach to jurisdiction that's been adopted there is just that. Stage one, consider whether there's a problem with the method that's been adopted. And if so, stage two, let's look at the proposed solution. And what we have here as a consequence of the Upper Tribunal's decision is a dichotomy in the way in which the courts and tribunals have approached the question of jurisdiction in a special method override case and the way in which they've approached it in a standard method override case. And of course, that is what we said was the important point of principle or practice that got over the second appeal threshold test. But with your permission, I propose to develop our submissions on those first three grounds of appeal in the order in which we deal with them in our skeleton argument. And then at that point, I propose to hand over to Mr. McGee, who will address the short but difficult technical point concerning the interaction of the standard method and a piece of legislation that blocks the recovery of input VAT on expenditure incurred to provide business entertainment. It's our fourth ground of appeal. But before turning to the detail of our grounds, let me, if I may, just frame our submissions by taking you first to the legislation which underpins the right to deduct, together with the principles identified in the case law relevant to the interpretation of that. And let me start, if I may, by taking you to Article 168 of the Principal VAT Directive, which sets out the basis for the right to deduct in EU law. That's your first authority bundle, page 5, behind the first tab. And you see it tells us that insofar as goods and services are used for the purposes of the tax transactions of a taxable person, the taxable person shall be entitled in the member state in which it carries out those transactions to deduct the following from the VAT that it's liable to pay. And then it's A, we're interested in the VAT due or paid in that member state in respect of supplies to him of goods or services carried out or to be carried out by another taxable person. So, insofar as they are used for the purpose of making taxable supplies, a taxable person can deduct the VAT on goods and services bought in to make those supplies. If you then turn ahead to page 8, please, you'll see Article 173. And Article 173 deals with proportional deduction in the case of taxable inputs that are used to make both taxable as well as exempt supplies. So you see it tells us, in the case of goods or services used by the taxable person, both for transactions in respect of which VAT's deductible and pursuant to Article 168, and for transactions in respect of which VAT is not deductible, only such proportion of the VAT as is attributable to the former transactions shall be deductible. And then we're told that the deductible proportion is determined in accordance with Articles 174 and 175. 174 over the page on page 9 makes provision for the standard turnover-based means of apportionment. Can I just invite you to look at 174 sub 1, please? You'll see that set out.
Yes.
So what we have there is a method that's incredibly easy to apply, but in consequence is somewhat rough and ready, being as it is based on the assumption that it costs the same amount in terms of VAT-bearing inputs to generate £1 of taxable income as it does to generate £1 of exempt income. That's the mathematical assumption that underpins the turnover-based calculation. And I'll return to that when I develop my submissions on the suitability of the standard method as a reliable proxy in this case. And recognising the limitations with the standard method, the Principal VAT Directive allows member states to authorise or require some alternative means of apportionment. We can see that on the same page, page 9, at the top of the page you'll see Article 1732. And you see, member states may take the following measures, and then little c, authorise or require the taxable person to make the deduction on the basis of the use made of all or part of the goods or services. Now, the relationship between the standard method and the ability for member states to authorise or require some alternative was considered by the European Court in its judgment in Volkswagen Financial Services, VWFS. Can I ask you to turn out your second authority bundle, please? It's tab 19, page 547. For present purposes, the facts are immaterial. I'm going to ask you to turn straight to page 554, please.
What tab 19?
Tab 19 begins at page 547 and then page 554, please, my lady, in the judgment of the European Court. And if you have that at 48, the court says, in this case, given that the general costs allocated to VWFS's retail sector concern goods and services used to effect both transactions giving rise to a right to deduct and transactions not giving rise to a right to deduct, a deductible proportion must be established in accordance with the relevant provisions of the directive. And then in 49 and 50, the court summarises the legislation I've just taken you through. But then in 51, you see the court says, according to the court's case law, member states may, as a result of that provision, apply for a given transaction a method or allocation key other than the turnover-based method, on condition that the method used guarantees a more precise determination of the deductible proportion. And if you look at 52, the court there talks about a method which identifies the taxable use of residual inputs with the greatest possible precision.
Where's that?
52. And you see, must ensure that the method for calculating the right to deduct makes it possible to ascertain with the greatest possible precision the proportion of VAT relating to transactions, etc. However, the court then tempers that somewhat in 53 when it says, in that regard, the courts nevertheless specified that the method chosen must not necessarily be the most precise possible, but that, as is apparent from paragraph 51 of this judgment, it must be able to guarantee a more precise result than the result which would arise from the application of the turnover-based allocation case of the standard method. So,
what's an allocation key? Does it just mean an allocation
method?
Method.
Or be it the special method, standard method.
Okay.
I think it's just Euro speak, my lady.
Euro speak for method.
Yeah.
Okay.
Yeah. There's anything magic in that.
No. Okay.
So, in circumstances where a member state's taken advantage of the option conferred by Article 1732C, and it's authorised or required some method in order to determine the use of VAT-bearing costs other than the standard method, we're told the allocation need not necessarily be the most precise possible, but it must produce a result that's more precise than the standard method. So that word use keeps cropping up again and again. Before considering what's meant by that word, how we should go about identifying use, can I just take you next to the provisions in domestic law that give effect to the provisions in the directive that we've been looking at? So I'm going to ask you to bundle 2 of the authorities away for a minute and take out bundle 1 again. And I can start with the relevant provisions in the VAT Act behind tab 3. And if I can ask you to turn to page 92, please. Section 24 of the VAT Act, and the only thing I want to take you to here is the definition of input tax in section 24.1. it means in relation to a taxable person the following, that is to say, VAT on the supply to him of any goods or services, and they'll drop down, being in each case goods or services used or to be used for the purpose of any business carried on or to be carried on by him. And that can be contrasted with the definition of output tax in subsection 2. If I can take you next to section 25(2), please, on page 95, which is the foundation for the recovery of input tax. See, subject to the provisions of this section, he, the taxable person, is entitled at the end of each prescribed accounting period to credit for so much of his input taxes as allowable under section 26, and then to deduct that amount from any output tax that's due from. Section 26 we can find on page 97. And subsection 1 tells us the amount of input tax which a taxable person is entitled to credit at the end of any period shall be so much of the input tax of that period, that is input tax on supplies, etc. in the period, as is allowable by or under regulations as being attributable to supplies within 2, and then 2A we're concerned with taxable supplies, so attributable to taxable supplies. And then 3 tells us that the Commissioner shall make regulations for securing a fair and reasonable attribution. And the regulations in question here are the 1995 VAT regulations. Behind the next tab, tab 4. And provision is made for the standard turnover-based method in Regulation 101, which is on page 127. Unfortunately, its application is a little bit complex. But, let me explain it to you. Start with what 1011. Subject to various other regulations. The only one to note there is Regulation 102, which I'll show you is the provision which allows for the adoption of a special method. But subject to various regulations, the amount of input tax which a taxable person should be entitled to deduct provisionally should be the amount which is attributable to taxable supplies in accordance with this regulation. So, just pausing there broadly, the way the legislation works is that a taxpayer makes a provisional deduction of input tax for each prescribed accounting period, 3 months, before then adjusting the deduction at the end of the tax year, referred to in the legislation as the longer period. And I needn't take you to it, but for your note, there's a rather complex definition of longer period in Regulation 99(3) to 7, which you've got on page 119. I'm not going to take you to it. But the standard method can then be found in Regulation 101(2)(d) on page 127. So, where the taxable person does not have an immediately preceding longer period, as subject to subparagraph E below, there shall be attributable to taxable supplies such proportion of the residual input tax as bears the same ratio to the total of such input tax as the value of taxable supplies made by him bears to the value of all supplies made by him in the period. Now, residual input tax, that term residual input tax, is defined in sub-regulation 10 on page 129. Input tax incurred by a taxable person on goods or services used or to be used to him in making both taxable and exempt supplies.
That's 101.10.
101.10, my lady, yes. But a couple of points to note on Regulation 101(2)(d), which introduces the standard method. First, it said only to apply in circumstances where a taxable person does not have an immediately preceding longer period. So essentially to a taxpayer in their first year of business. Second, Regulation 1012D, we're told, is subject to 1012E, which you'll see allows the taxpayer in that first year of business to instead apportion residual input tax according to use.
Sorry, that was Regulation 101.
1012E.
I see, yes.
So again, applies during that first year
Yes,
in business. But other provisions in the regulation then ensure the standard method has a wider application, that it isn't just confined to that first year in business. So if I can ask you to look at 1012F, please. So now, where a taxable person has an immediately preceding longer period, and subject to G below, his residual input tax shall be attributed to taxable supplies by reference to the percentage recovery rate for the immediately preceding longer period. So what it's telling us is that an established taxpayer calculates their provisional deduction by applying the rate of recovery for the immediately preceding tax year, the immediately preceding longer period. Subject to G, and G, you will see, allows the use of the standard method on a period-by-period basis. So they may instead use the calculation specified in D, and we've seen that D, that's the provision that sets out the standard method, or introduces the standard method.
Can I just go over that?
Yeah.
I don't know if it matters actually, but D is the standard method,
Yeah.
and I hadn't, I confess, focused on the words about the preceding longer period before. They had passed me by. But anyway, we've got the standard method there, which is a values-based, turnover-based method. E then seems to be a permission to say you don't have to use that method if you want to come up with a different use-based method. Is that right?
As long as you're a new trader, because you look at D, where the taxable person doesn't have an immediately preceding longer period and subject to E.
Yeah.
So if you're a new trader,
so this is the new trader starts on the standard method unless they want to use a different use-based method.
Yeah.
But then you carry on down, and F says if you're not an established trader, F says you use the percentage you had
if
last year.
you are an established trader.
If you are an established trader. So if you're in your second or further years, you use the percentage you had last year, unless G, you just want to use the standard method on a quarter-by-quarter basis.
And then so the one remaining question, so you've got the final piece of the jigsaw, is how do you determine the percentage recovery rate for the immediately preceding prior period? And for that, we need to go to Regulation 107. And my lady, you're right, none of this probably matters, but it is important you understand the statutory code. So if I can take you to 107, which is page 158, please. And ignoring words that are irrelevant for present purposes, it tells us this applies where a taxable person to whom a longer period is applicable has provisionally attributed an amount of input tax to taxable supplies in accordance with a method, he, and then if you drop down to D, shall, where he's provisionally attributed residual input tax under 1012F, determine for the longer period the amount of residual input tax which is attributable to taxable supplies using the calculation specified in Regulation 1012D, which is, of course, the standard method.
So if you've got an established trader who's using the standard method on a quarter-by-quarter basis, D tells you have to do, those are provisional allocations, and you have to do the same exercise over a longer period.
Yeah.
Which is your full year.
Broadly, which is your full year. So yeah, so at the end of each longer period, a trader to whom Reg 101 applies That's a trader's not on a special method, say. At the end of each longer period, the trader recomputes their entitlement by applying the standard method to that longer period. And the rate of recovery for that longer period, arrived at by applying the standard method, then fixes their provisional entitlement quarter by quarter in the next tax year.
Yeah.
And so the cycle continues. And that's how the standard method is given that wider application. So it's a bit more complicated than the directive, but that's how the standard method is introduced in our domestic law. But as envisaged by Article 1732 of the directive, the UK VAT legislation makes provision for circumstances in which the standard method either may not or does not apply. You've seen one example already in Regulation 1012E, the new trader that in their first year can adopt a use-based allocation fee. Another such provision is Regulation 102 of the VAT Regulations, which allows the commissioners to approve or direct the use of a bespoke means of apportionment. You find that at page 134. Subject to various other provisions, this is 1021, subject to various other provisions, the commissioners may approve or direct the use by a taxable person of a method other than the standard method, often called a special method or a peasant partial exemption special method. And finally, the legislation recognises that the result produced by the method employed, be it standard or special, may be unreliable. And in those circumstances, the legislation mandates the use of an alternative method, an override calculation. And of course, it's the standard method override that's in issue in this appeal, which is introduced by Regulation 107B. If I can take to page 161, please. Oh, so 162. Is 162?
Yes.
Yeah, sorry. Did I say 161? I'm sorry, 162. And you see there, paragraph 1 tells us, again, ignoring words that are immaterial, this regulation applies where a taxable person has made an attribution under Regulation 107, that's the longer period attribution, according to the method specified in Regulation 101, so the standard method. And that attribution differs substantially from one which represents the extent to which the goods or services are used by him or to be used by him, or a successor of his, in making taxable supplies. Subregulation 2 then tells us what the taxpayer has to do if the regulation applies. They have to calculate the difference and account for that on their next return. And I don't think I need to take you to it, but Regulation 107C tells us whether the difference between the standard method and the use-based allocation is substantial. It defines the meaning of substantial.
I was going to ask you where we found that.
Ah, what page?
That's 107.
164. 107 capital C.
Thank you.
Perhaps just have a quick look at that as you asked.
Okay.
Thank you. Now, finally, materially similar override legislation applies in the case of a taxpayer using a special method approved or directed under Regulation 102. And the reason I'm taking you it's relevant when we come to the question of jurisdiction. Because the question of jurisdiction has been answered in a rather different way. But Regulation 102A, which is page 138, deals with the special method override, and it tells us, notwithstanding, this is 102A1, notwithstanding the Commissioner's power to serve a notice under Regulation 102, So that's a notice directing the use of some other special method. Where a taxable person is for the time being using a special method, and that method does not fairly and reasonably represent the extent to which goods or services are used by him or to be used by him in making taxable supplies, the Commissioners may serve on him a notice to that effect, setting out their reasons in support of the notification and stating the effect of the notice. And Regulation 102 over the page, you have a look at that, you'll see that the special method override applies in the same way.
102B are we on?
102B, page 139, my lady. You'll see that the special method override applies in the same way as the standard method override.
Can we just pick away a little bit of that?
Yeah.
Because the language of the standard method override,
Yep.
107B, is that the attribution on the standard method
Yep.
differs substantially from one which represents the extent to which the goods or services are used by him or to be used by him, ...
Yeah,
in
yeah.
making taxable supplies. So you're looking at an attribution, a provisional attribution, or an attribution of the longer period, which differs substantially from what would represent the extent to which the goods or services are used for taxable supplies. And then we have a definition of substantial, which is 50,000 or whatever. So the question for a tribunal looking at a 107B case is whether the standard method attribution differs substantially from what the taxpayer says represents the extent to which the goods or services are used in making taxable supplies. So you've got that's what they're looking at, isn't it?
What you say?
Can I finish off
Yeah,
my question?
of course, sorry, yeah,
then
of
you
course
get
you
your
can.
chance.
Yeah.
So just anyway, that's the language of it. At the moment, I just wanted to make a language point. Then you look at what the special method override says. So what I'm really putting to you is it really right to say that these are parallel or comparable systems? Because the special method override at 102A starts from the predicate that a taxable person is using a special method that's been approved or directed. And 102A1B says that the method, the special method, does not, it's a much more hard-edged question, does not fairly and reasonably represent the extent to which goods or services are used by the taxpayer in making taxable supplies. So in other words, it fails to do the thing that it's intended to do, which is to arrive at a proportionate outcome. And that's when the Commissioners can serve a notice, and then you go into whatever the procedure is that happens next. So it's just that the question is a bit different.
Well, you say the question's a bit different. And can I come back to the way you expressed it, my lady?
Yeah, sure.
When you said the taxpayer's got to ask themselves this question in the context of the standard method override. You said that the taxpayer's got to ask themselves whether there's a substantial difference, assuming that the onus is on the taxpayer. When I take you to some of the authorities in this area, notably a case called Temple Finance, we'll see in that case it was the revenue who were taking issue with the application of the standard method and saying, look, we the revenue don't think that the attribution that we arrive at by applying the standard method is a reasonable proxy for use. And we the revenue think you should be applying an override calculation.
Yeah, I'm sure it can go both ways. It's really just the language point. It's a bit different, the way it's expressed.
The language is, I take your point, my lady, the language is slightly different. Attribution differs substantially rather than does not, the attribution, the method does not fairly and reasonably represent. But with respect, my lady, I'd say that's a distinction without a difference. They're both posing fundamentally the same question. Does the method that has been employed, or is that method, a reasonable proxy for use? And if the answer to that question is no, either because the Commissioners say so, Regulation 102A, or we just form the view, no, Regulation 107B, then the taxpayer has to do something. What they have to do is identify a use-based calculation, calculate the difference, and account for it. So the consequence is the same. They both have in mind the same problem. The method that's been employed doesn't work. And they both envisage the same solution. And as I say, I will return to this when we come to the question of jurisdiction. But let me, if I may, put the legislation to one side now and turn to consider what's meant by use, that word that keeps cropping up again and again, because it's a concept that isn't defined in the legislation. And the most helpful starting point there is a judgment of Mr. Justice Warren in a case called St Helens School, which is also in tab 1 of your authorities bundle behind tab 8, that's page 227. And let me, if I may, just put the case into context. A private school constructed a swimming pool and sports hall. And the case was concerned with the amount of input tax that the school was entitled to recover on the construction cost. And that issue arose because although the supply of education was at that time exempt, the school granted a taxable out-of-hours licence to a wholly owned subsidiary, which in turn operated a sports club. And the school applied to use a special method based on the physical use of the complex by respectively itself and the subsidiary. And the commissioners rejected the use of the special method, insisting that the school should instead apply the standard method. And both the tribunal and Mr. Justice Warren upheld that decision. Can I ask you to turn first, please, to page 242? In paragraph 49, His Lordship summarises the method that had been proposed, but actually it's paragraph 50 I'm more interested in. He says in 50, I see no reason why an attribution method along the lines proposed is to be ruled out of consideration in limine as an alternative method for the purposes of Regulation 102. It may be that on the facts of a particular case, the physical use of a building or chattel by a third party may be a very good proxy for the use, for that purposes, of the taxable person. I therefore agree with Mr. Thomas, who appeared on behalf of the school, that the tribunal's first reason for rejecting the school's proposed special partial exemption method cannot be supported. So a physical proxy can't be ruled out in limine. So far, so good for school. But in approaching the question whether some other proxy should indeed be preferred to the standard method, Mr. Justice Warren then went on to explain that the observable terms and features of the taxpayer's business had to be identified, as well as the wider context in which the expenditure had been incurred. And we can find that in paragraph 60A on page 244. And if I can just invite you to read 60A, please.
Yeah, I'll do that.
Some old friends in there, aren't
There are indeed some of the great names of VAT in that
there?
paragraph.
Some of the less great names.
But you'll see it's a little F where he talks about the need to have regard to the observable terms and features of the transaction, wider context in which it came to be carried out. Now, His Lordship then went on to consider a submission that had been advanced by Ms. Seymour, who had appeared before him on behalf of the revenue. Can I ask you to turn to paragraph 63, please, on page 246? And he says that Ms. Seymour acknowledges that a fair...
Sorry, which paragraph are we?
Paragraph 63, my lady,
That's
page
right.
246.
Just catch up. Yep.
he says, yeah, Miss Seymour acknowledges that a fair and reasonable attribution to the taxable supply has to reflect the use of a relevant asset in making that supply. She refers to the use which is to be identified for VAT purposes as the economic use. She accepts that physical use may reflect economic use, but says that it doesn't necessarily do so, and she submits that any allocation or special method must give a credible result in economic terms. And Mr. Justice Warren then goes on to agree with that submission, the need to identify.
Well, that must be right, mustn't it? So 63 that's right, isn't it?
That's right, and he goes on to agree with that. This is the submission that was advanced on behalf of the Crown, and you may say pretty obviously his lordship goes on to agree with it. So if you then look at para 75, he agrees with that submission. And can I just invite you to read 75 and 76, please?
Yeah.
Thank you. And then he tells us in the first sentence of 77 that on the facts of the case, the overwhelming economic use of the new sports complex by the school was in providing education. You see his conclusion summarised in that first sentence of 77. But a point I'd ask you to note is this, that in paragraph 76 that I invited you to read, Mr. Justice Warren tests the reliability of the school's method by considering the counterfactual situation in which there was no taxable out-of-hours licence, no taxable supplies. And he concludes that the out-of-hours licence had no bearing on the economic use of the new sports complex. The presence or otherwise of the out-of-hours licence was immaterial to the scale, nature, composition of the package of services supplied to the parents of the fee-paying students. And I'll return to that sort of counterfactual analysis, the idea of a counterfactual analysis as a means of identifying and measuring economic use when I turn to the decision of the FTT in this case. But just sticking with the authorities for the moment, the approach adopted by Mr. Justice Warren in St Helens School was subsequently approved and applied by this court in its judgment in London Clubs Management, a case with some similarity to that before you. That's in your second authorities bundle, tab 13, page 360. And I say this has some similarity to the case before you because it too concerned a casino that argued that a floor space based apportionment was a better proxy for the economic use of its overhead costs than the turnover based standard method, albeit in that case the taxpayer was applying to use a special method, wasn't concerned with the override. And in that case, the FTT, Upper Tribunal, and this court all agreed with the taxpayer. The judgment of the court was given by Lord Justice Everton, Lord Justice Ward and Lord Justice Pitchford simply said they agreed with him. Can I ask you to turn to paragraph 34 of his Lordship's judgment, page 367, please, where he identifies the legal principles to be applied in a case of this nature. 34, he says, a fair and reasonable attribution to a taxable supply must, for the purposes of the provisions in the directive and regulation 102D of the regulations, reflect the use of a relevant asset in making that supply. In assessing that use and its extent, consideration is not limited to physical use. The assessment must be of the real economic use of the asset, that is to say, having regard to economic reality in the light of the observable terms and features of the taxpayer's business. And as he then says in the first sentence of the next paragraph, 35, those principles were well captured by Mr. Justice Warren in St. Helens School. And he then goes on to set out some of the passages in Mr. Justice Warren's judgment that I've taken you to, including that paragraph 76 that I highlighted, where Mr. Justice Warren embarked upon his counterfactual analysis. And then his Lordship tells us, first sentence of paragraph 38 on page 369, I agree with Mr. Justice Warren's approach and analysis. And in 39, his Lordship makes the point that Mr. Justice Warren had in fact anticipated later judgments of the European Court that stress the need to appreciate or have an appreciation of economic reality when considering VAT. I think that's probably what you had in mind, my lady, when you said it's obvious, isn't it? It's that later case law of the European Court of Justice. Then in paragraph 40, his Lordship considers the decision of the old VAT Tribunal in the case of Aspinall's Club. It's another casino case in which the taxpayer had applied to use a floor space based special method, but one where the FTT had found that the commissioners had rightly rejected that application. And you'll see in the first sentence of paragraph 40 on page 369, Lord Justice Etherton describes Aspinall's as another good illustration of the application of the relevant principles in the context of gaming and associated catering. And can I invite you to read, please, paragraph 40 of his Lordship's judgment, including the passages from Aspinall's he sets out, and I'll then make a few brief submissions on what's said.
Yep.
Thank you. And you'll note that his Lordship then says in the first sentence of 41, he agrees with the reasoning of the tribunal. So, if I may, I just want to spend a couple of minutes considering that reasoning, the reasoning that his Lordship agreed with. And you'll have noted that in paragraph 49 of its decision, the tribunal makes the point that most, if not all, the floor areas of the club are of mixed use. And then goes on to say that the costs incurred in one area might be used to make supplies in another area. You've got that in 49. So the tribunal there was grappling in its decision with this idea of dual use. But first point to note, it's quite clear the tribunal didn't consider the existence of dual use of itself rendered the floor space based apportionment fundamentally flawed. And indeed, were that the case, it must also have been true of London clubs. Yet in that case, we know that this court went on to approve the use of a floor space based apportionment. So how do we reconcile London clubs and Aspinalls? And the answer is that it all comes down to the significance or extent of that dual use. And that really is the very issue that the tribunal in Aspinalls, in the passages approved by Lord Justice Etherton, was grappling with.
So your phrase was, sorry, comes down to the
appreciation of the significance or extent of the dual use. And that is the very issue, really, that the tribunal in Aspinalls and these passages approved by Lord Justice Etherton, that really is what it's grappling with.
Sorry, can I go back a stage and
Yeah.
forgive me if I haven't quite gone on? Aspinalls rejected
Yes.
floor space as the proxy,
Yep.
and London clubs management said accepted
Accepted.
on different facts.
Different facts.
Da-da. And
Yep.
so there's
Yep.
all that stuff at 41 about it's all very fact sensitive.
All very fact sensitive. All very fact sensitive. But what we see is that there is no fundamental legal objection to dual use in a floor space based apportionment. Because we don't get into that sensitive fact sensitive analysis if there is. It all comes down to comparing or contrasting, asking the question, how significant is that dual use? And we see that from the economic analysis that underpinned London clubs, but as well as the economic analysis that underpinned the tribunal's decision in Aspinalls. An economic analysis that, as my lady says, led to a different outcome, but economic analysis nonetheless.
Economic analysis based on economic reality, because that's what we get from
Yes.
the CJEU, isn't it? It's all very realistic,
Yes.
commonsensical,
Yes.
factual.
Yes.
About how these residual inputs are used.
Yes.
In fact.
Yeah. Yeah, that's a fair summary. We wear commercial goggles, if you will, when we're asking and answering these questions. And we see the basis of the tribunal's economic analysis, its economic appreciation, in those paragraphs. So you see it says, it's the furtherance of gaming which causes and is seen as justifying commercially the decision to incur the expenditure. It says, here they say there's capital expenditure and ongoing expenditure incurred specifically to create and maintain the opulence and luxury, especially in the creation of spacious surroundings and general ambience, which is seen as commercially necessary to promote the highly profitable gaming business. And in a way, it's a little bit like St. Helens School. The expenditure in question was warranted by the highly profitable gaming business. An expenditure on the same scale, and of the same kind, would have been incurred irrespective of the additional use of the club to sell a few drinks or to serve a meal. At St. Helens School, the same sports hall would have been built irrespective of the taxable out-of-hours licence. So dual use isn't a showstopper. It all comes down to the facts and an appreciation of the facts, highly fact sensitive. And in London clubs, the economic analysis, that appreciation, was rather different. The facts were different. If I could just show you that, if I can jump ahead to paragraph 69 of Lord Justice Etherton's judgment is page 377. And he says there, if the reasoning and findings of the FTT, it was Judge Berner sitting in the FTT, were limited to those at paragraph 38 of the decision, I could see much force in the Commissioner's case. Paragraph 48 of the decision, however, sets out the critical finding of fact that although the catering activities of the respondent are not currently profitable, we are satisfied that they are businesses in their own right and are not merely ancillary to the gaming business. It was on the basis of that finding that the FTT contrasted and distinguished Aspinalls. That finding by the FTT at para 48 of the decision was a finding that the catering activity of the respondent was a potential source of profit and carried on as such independently of the respondent's gaming activity. Unless that finding can be ignored, it's in my judgment plainly impossible to say that the decision of the FTT was erroneous and should be set aside. And if we could jump ahead to paragraph 71, his lordship says that although he thinks that finding by the FTT, he describes it as remarkably benign, it couldn't be overturned on appeal. So in London clubs, then, notwithstanding a degree of dual use, a floor space-based apportionment there was approved. But what a comparison of Aspinalls and London clubs reveals is that cases of this nature are incredibly fact-sensitive. It's a point that my lady put to me, actually, absolutely right. They're incredibly fact-sensitive. And indeed, it's a point that Lord Justice Etherton goes on to make in his judgment. If I can ask you to turn back, please, to paragraph 41 on page 370. And perhaps just invite you to read 41 and 42, please.
Yeah.
Thank you. Thank you. So what the tribunal's faced with is a fact-sensitive exercise. This commercial inquiry that I think my Lady Justice Whipple put to me is it's common sense, isn't it? Yes, but it's common sense for the tribunal to identify and apply. It is common sense, but it's a fact-sensitive exercise. And with that in mind, there's one final passage, please, in the judgment of Lord Justice Etherton I'd like to take you to, please, before turning to the decision of the Upper Tribunal in this case. And addressing our grounds of appeal, and that's paragraph 74, page 378. And he says, further, as Mr. Hitchmo rightly emphasised, in order to ascertain the reasoning of the FTT, the decision must be read as a whole. It's not to be interpreted like a statute drafted by Parliamentary Council. Its reasoning and sense to be gathered by a fair reading of its entirety. This is true of every judgment, but particularly so of an expert tribunal which, like the FTT, includes non-lawyers. It seems to me entirely reasonable and appropriate to assume that the FTT, in reaching its conclusion on economic use of the relevant overheads and the economic reality of the respondent's business, took into account the findings of fact of 48 of the decision. Indeed, that would seem necessarily to follow from the fact that, it was on this basis, at para 48, the tribunal distinguished Aspinalls, on which the Commissioners relied as being analogous to the instant case. But it's what his Lordship says in the first part of that paragraph. Don't read the decision of the FTT as if it were a statute. Assume they got it right, that they'd understood and applied the correct legal principle. That's what I emphasise. And of course, there's a legion of authority to that same effect. We refer to much of it in our skeleton argument.
We're quite familiar familiar with that.
Yeah, and I'm not going
It
to
tends
get
to
into
come
it.
up a lot.
Yes. And for that reason, my lady, you'll be very pleased to hear I'm not proposing to take you to it. I'm content to work with Lord Justice Etherton's summary in that paragraph. But for completeness, we do identify the authority more extensively in our skeleton. So let me, if I may, put the authorities to one side now and turn to the Upper Tribunal's decision, which you have in your core bundle, behind tab 7, beginning at page 886. Sorry. And the primary issue for the Upper Tribunal was whether the FTT had erred in law by failing to engage with the arguments that had been relied on before it by my learned friend, by HMRC. Arguments which were said to establish why the appellant's standard method override calculation, that floor space-based calculation, based on the use of floor space, why it was an unreliable proxy for the economic use made by the appellant in its VAT-bearing overheads. And those arguments, together with the revenue's criticism of the FTT, are summarised by the Upper Tribunal at paragraphs 4 and 5 of its decision. That's page 87. You're probably familiar with this, but can I just ask you to remind yourself of what those arguments were, the nature of the argument? And the Upper Tribunal, of course, went on to agree with those arguments, agree with HMRC. But in doing so, it drew a distinction, an erroneous distinction, we say, between a case such as that before it, where the complaint's one of lack of reasons, and a case where the complaint relates to adequacy of reasons. And we contend that caused the Upper Tribunal to then adopt an overly formalistic approach in its analysis of the FTT's decision, ignoring that guidance that we've seen summarised by Lord Justice Etherton at paragraph 74 of his judgment in London Clubs, that final paragraph I've just taken you to. And if I can ask you to turn in the Upper Tribunal's decision to paragraph 60, please, page 99 of your sorry, I think maybe page 102 if you're working electronically, page 99 if you're working on paper. Sorry, there's a discrepancy with the page number. I'm not quite sure how that.
My core bundle's on paper, so I'm perfectly happy. I think we're all on paper.
All on paper.
It's paragraph 60.
Paragraph 60, page
Thank
99 if you're on paper.
99.
Right.
Thank
So the Upper Tribunal says here, we accept that it's now well established in the authorities Mr. Hitchman refers to, set out above, that judicial caution and restraints required when considering whether to set aside the decision of a specialist fact-finding tribunal on the basis of a finding of fact or adequacy of reasons. In particular, the FTT alone is the judge of the facts. Its decision should be respected unless it's apparent that the tribunal has misdirected itself in law. It's likely that in interpreting and applying the law in its specialist field, the tribunal will have got it right. Appellate tribunal shouldn't rush to find errors of law simply because they might have reached a different conclusion on the facts or express themselves differently. But then they go, so far so good, an accurate summary. But then, having said all that, we are satisfied that this ground of appeal is not a complaint regarding perverse or unreasonable findings of fact, evaluative judgments or adequacy of reasons given. The ground concentrates upon the FTT's failure to address a central issue in the appeal and a lack of reasons. And we say that there's no basis whatsoever to suggest that a different approach should be adopted in a case where the complaint relates to adequacy of reasons. reasons, as opposed to lack of reasons. If the complaint's made out, that's an error of law. But the approach to be adopted when investigating the complaint should be identical. And the guidance set out in those cases to which the Upper Tribunal was taken, and in the guidance it summarises in paragraph 60, that has equal application. And when viewed through the prism of that guidance, I'll show you the criticisms levelled against the First Tier Tribunal are as untenable as the reasons given by the Upper Tribunal for distinguishing that guidance in the first place. So with that submission in mind, please, let me turn first to consider the decision of the FTT before then going on to look at the Upper Tribunal's evaluation and criticism of that decision. The decision of the FTT, again in your core bundle behind tab 11, page 156. Starting at page 157, paragraph 6, you see the FTT sets out the legislation in issue before summarising in paragraphs 21 to 27, that begins on page 160, the principles found in the authorities that are relevant to the construction and application of the legislation. And I needn't spend any time on that because neither party suggests that the FTT had misunderstood those principles. Basically the same principles I've worked through with you this morning.
Yep.
Page 163, starting at paragraph 32, the FTT, you'll see, turn to the evidence. The short point I'd make here is that many of the FTT's findings of fact acknowledged a degree of dual use. What the FTT then grappled with, quite properly we say, was whether the dual use that it had found to exist as a fact was so extensive as to render the floor space-based apportionment an unreliable proxy, concluding that it wasn't. But just to illustrate, if I may, that the FTT made specific findings of dual use, can I just, by way of illustration, really just take you to a few paragraphs in the decision? Can I take you first to paragraph 64, please, on page 168? You've got the second sentence there, Mr. King explained. So Mr. King explained it was difficult to differentiate one gaming business from another, saying that a wheel in one casino is a wheel in another casino. However, the fact that the Hippodrome has a fantastic standalone restaurant, fantastic bars, fantastic theatre, was, he said, a help to gaming. He agreed that it was the experience of being in the Hippodrome with the full variety of offers in the Hippodrome that set it apart as a gaming venue. And then, same page, paragraph 66. Contemporaneous documents repeatedly refer to the theatre, Helio Steakhouse, and various bars as facilities and amenities. And the FTT then goes on to set out extracts from those documents. Further example, paragraph 77, please, on page 170. In evidence, Mr. Thomas confirmed that one of the objectives of the theatre was to put people into the casino to gamble. However, he explained that was also an objective of the theatre to pull people into the Hippodrome to eat or drink as part of the mix of products there. But it's that first sentence, evidence of pulling people in the casino to gamble, although the FTT then goes on to find that that transpired to be something of a pipe dream. And finally, can I take you to paragraph 83, please, on page 171. While a proportion of these customers would have been at the Hippodrome for gaming purposes, Mr. Thomas considered that as food was also available 24 hours a day at the bars and served at the gaming tables, most of the restaurant customers were not there for that reason, but accepted that there had been attempts to cross-sell the Helios Steakhouse with the Hippodrome's other products. So another finding of dual use. And just to put these findings into some sort of context, if I may, the Hippodrome has never argued against dual use. I don't need to take you to it, but just for your note, the transcript of the hearing before the FTT, where the FTT records one of my submissions, this is, for your note, this is supplementary bundle, page 7, tab 7, page 269, where in the transcript, I say quite clearly, we don't dispute there is some dual use. The question in this case is measuring the extent of that dual use, the significance of that dual use. And the issue for the FTT was whether the exempt use of those areas zoned as taxable was so extensive as to render the appellant's floor space-based override calculation a less reliable proxy than the standard method, which of course was a value judgment.
Sorry, just go. The issue for the FTT was, you say, whether the exempt use of those areas, and I lost the next
zoned as taxable. It's a floor space-based.
Concerned as taxable.
Zoned as
taxable.
Zoned, sorry, my lady. Yeah. Zoned as taxable.
So that's what the restaurants, the theatre, the
bars.
Not the bar. I thought the bars. Some of them were in the gambling spaces, so they were.
The bar itself was zoned as taxable.
I see. Yep.
And whether the exempt use of those areas was so extensive as to render the appellant's floor space-based override calculation a less reliable proxy than the standard method.
Please repeat the remainder of that. It was exempt use was so extensive.
So extensive as to render the appellant's floor space-based override calculation a less reliable proxy than the standard method.
Thank you.
Which is a value judgment.
But it's a turnover-based method, but it's also evaluative in a sense, isn't it? Don't worry. I'm going down a rabbit hole. Don't worry. But I got the point. It's a values-based, turnover-based.
No, when I say a value judgment, the overall question before the FTT required a value judgment. Yeah. That's when I'm using value in that context.
So value in that sense. Okay. Thank you.
And the FTT concluded that the floor space-based apportionment was a more reliable proxy, notwithstanding the dual use argument relied upon by HMRC. And what I want to turn to, or where I want to turn to next, are the FTT's reasons for arriving at that conclusion. So we've looked at the FTT's findings, or dipped into the FTT's findings. Can I now ask you to turn ahead to paragraph 107, please, which is page 175, where the FTT observes quite rightly that it's faced with, it says, a very fact-sensitive issue. And then in paragraphs 108 to 110, the tribunal summarises the submissions that had been advanced by my learned friend. But paragraph 108, it captures accurately the dual use argument. So for HMRC, Mr. Donwell contends that not only did HCL make economic use of the areas in the Hippodrome allocated to hospitality and entertainment for those purposes, but also used those areas for its gaming supplies, i.e. there was dual use of those areas. He says this was because gaming customers were attracted to the Hippodrome and encouraged to stay there because of the entertainment, and particularly the hospitality, and that this strengthened its gaming proposition over that provided by its competitors. This not only complied with the letter and spirit of the regulations requiring non-gaming areas to be available in a casino and for gamblers to take breaks, which Mr. Thomas accepted, but also gave HCL the opportunity to cross-sell gaming to customers who initially came for other purposes. And that after summarising some of my own submissions before it, the FTT turned to grapple with the key issue, whether the dual use that it had found to exist as a fact was so extensive as to render the appellant's floor space based calculation an unreliable proxy. So, if we can jump ahead to paragraph 115, please, the foot of that same page, page 176. The FTT explains that the Hippodrome can't be compared with other casinos. Have a look at 115 if you will.
So is 115 where it starts its own?
Accordingly, it's necessary to bear in mind.
Yeah, but do you say that's because we've looked at the recitation of HMRC's submissions and then the recitation of your submissions? This is where we're starting to get into the analysis.
I think it's yeah. I mean,
this isn't recording submissions. This is analysis.
He makes a couple of fairly obvious points before that in 113 and 114, which I would say are part of the overall analysis, but not material to the conclusion.
The analysis starts, you say, at
113. So 114, for example, refers to St. Helens, need to consider the observable terms, etc. So it sets out a couple of legal principles in 113 and 114, but then 115, we get to the meat of it, accordingly. So, accordingly, necessary to bear in mind that HCL was seeking to create a Las Vegas experience at the Hippodrome for a variety of customers and provide a range of products under one roof. And then goes on to say, for that reason, you can't compare the Hippodrome with other casinos, high-end or mass market.
Mm-hmm.
Then in 116 and 117, the FTT finds that in contrast with the restaurant bars, in contrast, sorry, with other casinos, the restaurant, bar and theatre in the Hippodrome aim to compete with the very many other theatres, bars, restaurants in the West End. And that's all feeding into the FTT's analysis of the economic use of overheads. What's driving the expenditure isn't merely a desire to attract custom from other casinos, but a desire to attract custom from other bars, restaurants, and theatres. And in 118 to 123, the FTT then turns to address specifically the dual use issue, whether the scale and importance of dual use is such as to render the override calculation an unreliable proxy. And if I can invite you to read, please, 118 to 123, and then I'll make some submissions on that.
And presumably you would also take us to 125 where you have the punchline.
I'm going to come to 125, my lady. Indeed, indeed. Yeah. But the paragraphs I've just asked you to read, what the FTT is addressing there is the significance of, say, the restaurant or theatre as an asset for gaming. So, for example, the point made in 119 is that dual use of the theatre, certainly so far as gaming is concerned, is insignificant. That goes directly to dual use. And an
Sorry, which paragraph?
119.
119, yes, I see.
The nowhere near the 5% crossover. The tribunal, they're clearly evaluating, well, to what extent is there dual use?
Just that particular dual use is theatre to gaming, is it?
In that paragraph.
As opposed to gaming to theatre or gaming to restaurants or bars.
Yeah, because the floor space based apportionment assumes that the theatre is used only to make taxable supplies. And say the revenue is not. It's also being used as an asset to promote gaming. So there's some economic use of that theatre to promote the gaming business. And the question, we said, well, we agree with that. But the question is, how much? Is the economic use to promote the exempt business, is it so extensive as to render the proxy unreliable? And the very issue that really the tribunal in Asplin was grappling with, and indeed this court in London clubs, and so too the FTT in this case, and 119 is a very clear example of that.
I mean, one would expect less crossover, presumably, between theatre and gaming than between bars and restaurants and gaming.
Yes, you would. But the restaurant, 118, is considering dual use of the restaurant.
No, it doesn't really tell you the extent of it.
It's grappling with it. And
it doesn't seem to be very much grappling with it.
With respect, my lord, we can't read this decision of the FTT as if it were a statute. We've got to say, did it understand the legal principles it was called upon to apply? And there's no real issue there. Yes, it understood the concept of economic use, which is a rather woolly concept. In applying that concept of economic use, did it grapple with the revenues arguments? And here we have examples of that. Now, the overall conclusion or the overall analysis may be, to paraphrase Lord Justice Etherton, remarkably benign, but that isn't really the question.
Well, my lady mentioned paragraph 125.
Yes.
I mean, if that was the question that the tribunal thought it was answering the wrong question, wasn't it?
I'm going to come to 125, my lord. Can I just leave that for a minute? I am going to
Yes. Though in a sense, these all seem to lead up to and be coloured by that question, which is the wrong question.
Well, as I'll show you, the Upper Tribunal did not see paragraph 125 as containing what it considered the material error of law, and that's a conclusion that the Revenue haven't taken issue with in the appeal before you. And that's why I just want to park that for a minute.
Yes.
I'll come to 125. It's an important paragraph, but it bears separate consideration. So I'm not ducking the issue, but I want to look at it in a moment. But 118, 119, clearly grappling with dual use. 120, the FTT you've seen refers to Mr. King's evidence and makes the point that if the principal economic use of the bars and restaurants was simply supporting or enhancing gaming, well, the Hippodrome would look completely different. It's already made findings in relation to the sort of food and beverage that may be on offer in a typical casino. That was 115 that we've looked at. And the point that the tribunal's making there is that to the extent that the space, ambience and offering in the bars and restaurant is far more extensive than that which would be needed if they were merely strategic gaming assets, then a significant economic use of the bars, restaurant and theatre must be for some other economic purpose.
It's not merely an adjunct to or an amenity for gaming.
Well, 120 says if it was all if everything was just about the gaming, the hippodrome wouldn't look anything like it looks today. It would be a different animal. So that's going beyond adjunct or amenity. This is look, it wouldn't look anything like this. This is grappling with dual use. Now, again, my lord, with respect, you may not like the way in which it's grappling with dual use. The question whether it is grappling is whether it is grappling with dual use. Because the Upper Tribunal's conclusion was they just ducked the issue. They didn't address the revenues argument. And I said, when you read this decision, read it fairly and as a whole. Read it with the principles in mind we're meant to be applying when we read an FTT decision, rather than read it like a statute. Then, yes, it did grapple with the arguments that were being advanced.
Well, let's take 120.
Yes.
Where do you see an evaluation of the significance of the dual use in 120?
The significance wouldn't look like anything, different animal. The phraseology there is drawing quite a significant contrast, not a small contrast, small difference, but significant contrast between what's happening in the hippodrome and the findings it's made in 115 that relate to a more typical casino. So it comes in the language. Did it say use the words dual use? No, it didn't. Does that matter? Equally, I would say no, it doesn't. This point we see merging in 120, different animal. The FTT then develops that point in 121 when it refers to St Helens School. And you recall a case where there was also dual use of the asset, the new sports hall, and one where the standard method was found to be the more reliable proxy. Why? Well, you've seen in that case, why? That's because irrespective of the taxable use, the out-of-hours license, the asset would have been designed, built to the same standard. And that's the contrast that the tribunal is drawing here in paragraph 121 of its decision. Contrasting St Helens, the hippodrome would be a different animal. So again, comparing and contrasting the degree of dual use. Now, in 122 and 123, the FTT then goes on to consider Aspinalls. Another case, as we know, where the standard method was preferred over the alternative proxy that had been put forward by the taxpayer. And why? Well, again, because like in St Helens School, the asset there, Aspinalls Casino, the club, would have been configured in the same way to the same standard, irrespective of the modest taxable supplies that were made. And the FTT, then, it again contrasts that with the case before it. It describes the hospitality on offer in the hippodrome as being of an altogether different nature to that on offer in Aspinalls. And again, the language, again, altogether different nature. That's the language of an evaluative judgment. So all casinos may need a bar and restaurant. It's the point that the tribunal's made in 115. But the bars and restaurant in the hippodrome are of an altogether different nature, necessary to enable the hippodrome to compete with other bars, theatres, etc. in the West End. The findings that have been made in 116 and 117. So this all hangs together. So again, it's grappling with dual use, the extent of that dual use. Now, one further point on 123, easiest to deal with now, and indeed 123. I'm coming to that point you preempted. I said I would. One further point on 123, easiest to deal with now. It relates to the use by the FTT of the word merely in 123. And you may recall when I took you to the Upper Tribunal's summary of HMRC's arguments, paragraph 4 and 5 of the UT's decision, the Upper Tribunal recorded HMRC as arguing that in expressing itself in this way, the FTT had asked itself the wrong question, which I think is the point you put to me, my lord. Applied the wrong test, and you know, as you quite rightly pointed out, the same language or similar language is used in 125. Yeah. Now there are three relatively short points to make about the way in which the FTT expressed itself here. First, fairly obvious one, we shouldn't read this decision as if it were a statute. We've got to gain the reasoning of the FTT by reading its decision as a whole. That comes back to that very orthodox guidance that you're well familiar with. The second point is this: in expressing itself as it did, the tribunal here was merely addressing a further aspect of the way in which the revenue had developed their case before it. To illustrate that, can I take you back to the 3 paragraphs in which HMRC's case was summarised, please? That's paragraphs 108 to 110, page 176. I took you specifically to 108 before, but let's look at 110. So in addition, Mr. Domnall contends that it's clear from the contemporaneous documents that HCL's principal activity is the operation of a casino, which, he says, is supported by the reference to the theatre and various bars on the Hippodrome in HCLC's accounts as facilities. The reference in its business plan as the operation of a casino as its principal activity, and the entertainment facilities being an important part of the overall offer of a casino. Indeed, its very name, he also relies on Hippodrome Casino. And you note there that the tribunal also refers back to the findings made in paragraph 66 of its decision that I took you to earlier, where it talks about the theatre and steakhouse as being facilities or amenities. And in then expressing itself as it does in 123 and 125 of its decision, the FTT really was merely discounting what was said in those documents that have been relied on by HMRC, as a reliable or definitive indication of the true economic use by the appellant of the bars, restaurants and theatre, etc., in the light of other evidence available to it. So really it's rejecting that argument that we see summarised in paragraph 110, considering and rejecting. And my third point's this, and it may be the most important. Even if you disagree and conclude that the FTT was applying some alternative or erroneous approach here when it considered whether the hospitality on offer in the Hippodrome was merely an adjunct to or amenity for gaming, you think that's the wrong test. That was immaterial to its overall conclusion. And my reason for saying it was immaterial to its overall conclusion is that was the conclusion of the Upper Tribunal in a passage of its decision that HMRC don't take issue with. The argument that the FTT had applied a mistaken test was the second of HMRC's grounds of appeal before the Upper Tribunal. Let me show you. If you go back to the Upper Tribunal decision, please. Page 93, paragraph 30 sub 2. The wrong test ground. Now, the Upper Tribunal's conclusions on ground 2 can be found in paragraph 96 of its decision on page 105. So it says, having said all of the above, considering ground 2, we're not satisfied that this ground materially adds to ground 1, i.e. failing to consider the dual use argument. The FTT's material error of law was in relation to the dual use issue. Even though it considered the wrong question at 125, well, obviously we would take issue with that, but let's assume that's right for a minute. Even though it considered the wrong question at 125, it ultimately applied the correct test as to which method guaranteed the more precise measure of economic use at 127. Therefore, any error in relation to this ground is not material. And that is a conclusion. There's no respondent's notice here that takes issue with that conclusion. So, in other words, even if 125 does contain the error of law that you put to me, my lord, that would not have provided a basis for setting aside and remaking the decision of the FTT. Just for completeness, let me also take you to paragraph 127 of the FTT's decision that you see referred to in that paragraph, which you'll find at tab 11, page 178. As such, we find that the floor space method, as set out in HCL's SMO calculation, does provide a more fair, reasonable and precise proxy of its economic use of its overhead expenditure than the turnover-based standard method, particularly given that most of those overheads are property related. Accordingly, appeal succeeds on this issue. That's just really the conclusion.
So 126 is sort of parasitic on what's come earlier.
Yeah.
You say, well, we see at 127 that the FTT had the correct question in mind, and you say, well, 125 we'll forget about because, well, you might think it's applying the wrong test. The Upper Tribunal didn't say so. But does that leave you saying, well, look, if para 126 is just parasitic, we have to look earlier for where the evaluation is. And even if the tribunal wasn't merely considering what paragraph 125 suggests, you just don't see them considering the dual use question.
Well, but let me take that in stages. I mean, 126, yeah, we don't see any further analysis of dual use. I take that. 125, you have my submission that the tribunal wasn't there applying the wrong test. It was actually addressing a rather different argument that had been advanced by my learned friend. But even if you are against me in that submission,
I mean, at best it's irrelevant for your point of view.
At best it's irrelevant.
Yep.
Yeah. Which then leaves us with the analysis we've worked through starting at 115. The question then is whether in paragraphs 115 to 123 we find some consideration, or there's evidence of consideration of the dual use issue. And you have my submissions. We've worked through this, my lord, and reading the decision of the FTT in a fair way, in the light of the guidance that we've seen summarised by Lord Justice Etherton and indeed the Upper Tribunal, if we read the decision with that guidance in mind, then there is a consideration of the dual use issue. Now, you may say, well, it's not that extensive, it's a bit thin. I'd accept that, but that's not the question. The question is whether the decision is devoid of any consideration or analysis. And reading this decision fairly, it isn't devoid. What the tribunal embarks upon is this overall evaluative judgment.
On your case, you say the reasons are sufficient because you say there's no difference between insufficiency and lack of.
Yes.
Got that point. And if we were with you, you say we should say that the Upper Tribunal went wrong. There's a big circle because then we'd be left remaking the decision ourselves. So we'd have to look back at the FTT and ask ourselves whether we thought there was an adequacy of decision making. Is it adequate? In your solution?
I would say it is adequate. Had that been the basis of the challenge before the Upper Tribunal, I would equally have been defending the decision on the basis of adequacy. The tribunal grappled with the issue and expressed a conclusion that the method that had been employed by the taxpayer was reliable, or more reliable than the standard method. But the complaint that has been levelled is not one of adequacy of reasons, lack of reasons. And
yeah, but what I'm saying is, even if we're with you on that, where that gets you is that we set aside the Upper Tribunal and we have to make the decision. Or we could remit it, but frankly, we could at this stage probably do. Well, we'd have to decide what we were going to do about it. And one thing we could do about it is look for ourselves.
Or with respect, my lady, I'm not sure you should be remaking the decision or considering adequacy, because the complaint that has been made, the only complaint that has been made in relation to the FTT's decision is one of lack of reasons. And the Upper Tribunal was very, very clear in that, in its decision, drawing that distinction it did in paragraph 61. That's the only complaint that's been raised. And if that complaint is not made out, which in my submission it isn't, then the decision of the FTT should stand. But that notwithstanding, if you read this decision, sure, it may not be a decision of this court, but as a decision of the FTT, can you say the FTT grappled with the issues it was called upon to grapple with and expressed a conclusion with the correct legal principles in mind? Yes, it did.
And one trouble is, in the passages preceding 125,
yes,
forget about 125 itself.
Yeah.
You can see them saying things that would be relevant to a 125 test, but don't really answer the economic use test. I mean, when you say it wasn't just about gaming, well, that looks to a sort of adjunct. It doesn't tell you about whether there's dual use. It isn't just about gaming, but that doesn't exclude dual use at all.
The whole decision is predicated on there being dual use. But the question is whether that dual use is so significant as to undermine the credibility of the override calculation. And the tribunal tests that question, whether dual use is so significant. It tests that question by saying, well, let's have a look at the bars and restaurants here. Are they simply designed to serve the gaming clientele? Is there some wider purpose? No, there is a wider purpose. They want to compete in the West End. Would the club look the same were it not for that intention to compete in the West End? No, it would be a completely different animal.
But none of that is inconsistent with significant dual use.
Well, with respect, my lord, we would say it is inconsistent with significant dual use. That must be the tribunal's conclusion, because that was the very issue it was grappling with. It had set out the case relied upon by HMRC fairly in paragraph 108. And is there an indication in its decision it was grappling with that case? Yes, there is an indication in its decision it was grappling with that case. Precisely what it did in the paragraphs I've taken you to. It hasn't erred as a matter of principle. It may have arrived at a conclusion that sticks in your throat, for want of a better expression. Certainly did appear to do with the Upper Tribunal. But that's not the question. It comes back to that observation of Lord Justice Etherton, who
might be benign.
Might be benign, but hey, he said it might be benign, but it's not my job to go behind that. Not my job sat here in the Court of Appeal.
Yeah.
So that's the decision of the FTT. Where I'd like to turn next, and we're doing well on time, by the way.
Yeah.
Where I'd like to turn next is the decision of the Upper Tribunal and the reasons given by the Upper Tribunal for reaching a contrary conclusion. For reaching the conclusion that it was entitled to set aside and remake.
Yep.
Upper Tribunal's decision is behind tab 7, beginning of page 86. Can I ask you to turn to page 100 of your bundle, please? And in paragraph 63 on that page, the Upper Tribunal sets out its overall conclusion before going on to explain the basis for that conclusion. So you see, it says, we're satisfied that when the decision of the FTTs as a whole, the FTTs failed to address or engage with the case advanced by HMRC, that there was dual economic use by which the bars, restaurant and theatre were also significantly used economically to support and promote gaming. It therefore failed to give any reasons for rejecting the core of the case advanced by HMRC and for reaching the decision it did. And 64, it says, despite my submissions to the contrary, it wasn't convinced. Now, what were the reasons given by the Upper Tribunal for arriving at that conclusion? Look, para 65, the tribunal notes that the review had relied before the FTT on the dual use argument, and it said there was material before the FTT capable of supporting HMRC's case. Well, we'd agree, but that doesn't really go to the question that the Upper Tribunal is grappling with here. And indeed the same is true of the points made by the Upper Tribunal in paragraph 66. At 67, the Upper Tribunal summarises those key findings, that key part of the analysis in paragraphs 115 to 120 that we've worked through. And in 68, it says, it asserts really that in those paragraphs, the dual use argument is not engaged with. And with respect, that doesn't stand up to scrutiny. Because even reading the FTT's decision as if it were a formal legal document, there can be no real doubt that in those paragraphs, and I rely again, I place particular reliance on 118, there can be no real doubt that in those paragraphs, the FTT was grappling squarely with the issue of dual use. In those paragraphs, dual use of the theatre and restaurant. So to say in 68, the dual use issue is not engaged with, that's not a fair reading of the decision of the FTT. Indeed, you have my submissions, and would say the same is true of paragraph 120, where the FTT is grappling with that question, what's driven the scale and nature of the expenditure on the bars and the theatre and the restaurant. In paragraph 69, the Upper Tribunal does no more than summarise paras 121 and 122 of the FTT's decision. And its analysis of paragraph 121 can then be found in paragraph 70. It says there that the observation of the FTT that there would have been a difference without the theatre, bars and restaurants doesn't answer the dual use issue. But with respect, and you have my submission, the FTT there's posing the very counterfactual question that Mr. Justice Warren asked himself in St. Helens School. when considering the dual use of the new sports hall in that case. Don't forget that was in a paragraph of his judgment that was approved by Lord Justice Etherton in London Plus, paragraph 76. And as the FTT here had already found in paragraph 120 of its decision, the Hippodrome would have been a different animal were it not for the intention to have bar, restaurants, theatre that could compete with other bars, restaurants, theatres in the West End. So yes, there's some use of the bars and the like to service gaming clientele. And the FTT has made findings of fact to that effect, as I've shown you. But it also made findings of fact that were relevant to the scale and nature of the hospitality on offer in a typical casino. And the point that the FTT was making, to repeat myself, is that the scale and nature of the hospitality in issue before it was completely different. But nevertheless, in this paragraph, paragraph 70, the Upper Tribunal goes on to say, one of the points made by HMRC in favour of the dual use contention was that the logic of the SMO method presupposed that the gaming areas and the bars and restaurant areas were mutually exclusive and could be completely split up physically, so that, for example, they could be located in entirely different buildings. Yet this was plainly contrary to the economic reality of the situation. So from that perspective, the observation that the Hippodrome would be different without, say, any bars is potentially a factor in support of HMRC's argument rather than the reverse. Now, if I may, there are 3 points to make about what the Upper Tribunal says there. First, it's true that the logic of the override calculation presupposes that the gaming bars and restaurants, gaming bars, restaurants and theatre are all mutually exclusive. But that doesn't of itself render the override calculation fundamentally flawed. It doesn't of itself render it an unreliable proxy any more than it did in Aspinall's, London Clubs, St Helens School. Because there was dual use there too. So it's not a fundamental flaw.
Sorry, I think I've missed a point. I'd written down the logic of the override calculation. So your override calculation is that gaming and hospitality are mutually exclusive, the one from the other.
Yeah.
So your calculation is not based on dual use, it's based on the opposite of dual use, which is that you look at the areas that are primarily given to each thing, and that's how it works. And then you go on to say that doesn't make it an unreliable proxy because it does incorporate dual use. I don't understand that.
No. Sorry, my lady, I probably didn't express myself very well. So what the Upper Tribunal here says about the logic of the calculation, assuming exclusivity, that's quite right. I don't take issue with that.
Can you just point me to where the UT says that? So where's the bit that's right?
Yeah, so it says, para 70, one of the points made by HMRC in favour of the dual use contention, you've got that?
Yeah.
Was that the logic of the SMO method presupposes that the gaming areas and the bars and restaurant areas were mutually exclusive and completely split up physically. So that, for example.
Yeah.
Yeah.
So you agree with HMRC's criticism of your SMO method in this respect, do you?
Well, I agree that that is the logic of the method. But the question is whether that in itself means that the method is fundamentally flawed. And my answer to that is no. Because there was also dual use in Aspinall's. We've seen that. The same sort of dual use. Dual use in London Clubs. Dual use in St Helens. But the question in each case is whether that dual use is so significant as to undermine the reliability of the proxy. So it's not a fundamental flaw, it's merely a factor to feed into the overall economic analysis.
So I think you'd say, wouldn't you, that the whole point about a floor space area is that you do divide up your whole floor space into sort of three sorts of things. One that's given over to exempt, so your gambling tables. Two that's given over to entertainment, so restaurants, bars and whatnot. And three, the stairwells and lavatories that might be both. And you use 1 and 2 as your basic split. Yeah? Is that how you do it?
Yeah.
So inevitably you are juxtaposing your idea of exempt and taxable and saying that, and so you'd have a case like LCM where you could still use that kind of approach, even though there was obviously some dual use and your bars were used by people who were gambling and so on, and then Aspinall's is the one that goes the other way and says you can't.
And St Helens also dual use, because this sports hall is being used part of the time for kids to do PE, and it's being used part of the time by the local community, the out of hours license. And so there's dual use. And but the question is, and well, does that dual use does that mean that a floor space based apportionment is a fundamental flaw? No, it's not a fundamental flaw. Were it a fundamental flaw, then the careful economic analysis we see set out in Aspinall's London clubs, it's all pretty pointless. So, dual use, not a fundamental flaw. The question that the court or tribunal has to grapple with is
whether it's economic reality or not. So LCM said it was on the facts there, and Aspinall said it wasn't on the facts.
And how do you reconcile the two? It comes down to an appreciation of how extensive is that dual use. It's a balancing exercise. How important is it? That's the question.
Well, there's a bigger question, actually, isn't there? It's about whether the floor space method that you've used as your alternative reflects economic use, really.
That is the question, but in answering that question...
A component of that is accepting there's some element of dual use.
And then the real answer lies in the question, well, how significant is it? Because a little bit doesn't matter. We've seen that from London clubs. But a lot leads to a completely different outcome. We've seen that in Aspinall. So it's that question you've got to grapple with, well, you can look at the significance of the dual use and say, well, is it so significant as to render the calculation unreliable? And that is the question we said the FTT grappled with here. And the point made by the Upper Tribunal in 70 about the logic that underpins the SMO method, well, yes, it's true, but is really neither here nor there. I don't think there's anything else I actually need to say on paragraph 70. In paragraph 71 of its decision, the Upper Tribunal then considers the paragraphs in its decision where the FTT had looked at Aspinall's and that use of the word merely. Now, I've already addressed the use of the word merely and also the language of paragraph 125. The only additional point I'd make on 71 is this. As the Upper Tribunal says here, through its use of the words not merely in paragraph 122 of its decision, the FTT was implicitly accepting that some of the purpose of the expenditure on the bars, etc., was to provide an attractive atmosphere to gaming. So again, there's an acknowledgement there of dual use. And the Upper Tribunal accepts that. Now, the Upper Tribunal then goes on to consider 4 further paragraphs in the decision of the FTT, which, well, in exchange with my Lord Justice Newey, I've already accepted, don't really take the dual use argument any further forward. This is all really providing then the setting for the FTT's overall conclusion in paragraph 127. So nothing to say there. And then in paragraph 78 and 79 over the page on 103, the Upper Tribunal really just repeats the conclusion that is already expressed in paragraph 64. No further analysis there. really, at the heart of the Upper Tribunal's analysis for rejecting the FTT's, the heart of its analysis for its conclusion that it could overturn the decision of the FTT is really that assertion in paragraph 68 that the dual use issue is not engaged with.
One question, please, on para 79.
Yes.
Where the Upper Tribunal says nowhere in the decision did the First Tier Tribunal give reasons for rejecting HMRC's contention that the taxable areas were used in part for exempt business, such that there was dual use. Just pausing there, you say that's wrong, and you've taken us to the paragraphs that you say grapple with dual use in some respects. What about the next bit of it, which is a criticism that the FTT did not give any reasons for why, if there was such dual use, which you say was looked at, the SMO method, which assumed exclusivity of use, could be more precise than the standard turnover method, or fair, reasonable, and precise. So, where's the other bit? Have we looked at where you say the FTT explain why the SMO method is a better one than the ordinary standard method?
Yeah, we see
Just
that.
Just give me the paragraphs to note.
Yeah, let me. The paragraphs we've looked at already, where the FTT considers the extent of dual use, together with, and there is one further paragraph that's relevant to that second stage of the analysis, the comparison. If I can take you back to the decision of the FTT, please, at page 1, tab 11, page 178.
That's 127. So you just say that's the conclusion there is it does provide a more fair, reasonable, and precise. Why?
It's also 126, my lady. That's the second sentence in 126.
Gaming generates higher turnover per square foot than hospitality. Doesn't that go against you? Isn't that the very point that HMRC is making? If I misunderstood.
No. If you go, you also have a look at paragraph 103 of its decision, the finding of fact there that the FTT is referring to. So let me turn back to it. So this is an example that had been relied on in evidence. In support of floor space as opposed to turnover approximation of these costs, the majority of which relate to property, Mr. King gave the example of an electronic roulette terminal, sits in a space of 1.2 square metres, and can only be used by one person at a time. It sits in a storeroom taking up a further 0.3 of a square metre. Terminal has a turnover of 400,000 a year. By contrast, table in the steakhouse also sits in a space of approximately 1.5 square metres. However, it's normally used by 2 people at a time who sit in chairs and need another 0.4 metres space. In the next table. So the steakhouse table also required a bar, kitchen, etc. And the point the tribunal's making there is it costs more in terms of the use of VAT-bearing overheads to earn £1 of taxable income than it costs to earn £1 of exempt income. It's that mathematical truism that underpins the standard method that I identified before. The method assumes that it costs the same in terms of use of VAT-bearing overhead costs to earn £1 of taxable income as it costs to earn £1 of exempt. And what the tribunal's saying by reference to that example in 103 is, well, that's not the case here. It costs more in terms of your consumption of VAT-bearing overheads to earn £1 of taxable income, a lot more, than it costs to earn £1 of exempt. So that's where the tribunal is grappling with the question that my lady put to me.
That's where you say, so we looked at 126 and 127 of the FTT to answer para 79 of the UT, why the area-based method was better than a turnover-based method.
Yeah. Okay. So when we read the FTT's decision, it's told us in some detail why it considers the floor space based apportionment to be a reliable proxy, notwithstanding dual use. That's the analysis we've worked through, and then it says, well, okay, well, what about the standard method? Is it more reliable than the standard method? And that's where we go to 126 and the example of the electronic roulette wheel. The example, the evidence of which is set out at 103. That's where we find the basis for the tribunal's conclusion.
And that's your answer to paragraph 80 of the UT as well. It says, we agree the FTT did not explain why, if there is a dual use, the SMO guarantees a more precise result. And you say it does look at 126 and 127.
Yeah. So, really, drawing our submissions on the ground one of our grounds of appeal together, we contend that although in paragraph 60 of its decision the Upper Tribunal noted that appellant tribunals shouldn't rush to find errors of law simply because they may arrive at a different conclusion, in the present case, well, with respect to the Upper Tribunal, they've done just that. And if the test to be applied when reading a decision of the fact-finding tribunal is whether the parties know why they've respectively won and lost, that test is satisfied by a fair reading of the decision of the FTT as a whole.
So the proposition there is that HMRC could know from the decision why they'd lost.
So unless I can assist you further on our first ground of appeal, I'm going to turn now to consider our second ground of appeal, jurisdiction. As I mentioned this morning, even if you disagree with the submissions I've made so far and conclude that the Upper Tribunal was right to set aside the decision of the FTT for want of reasons, that in itself doesn't lead to the conclusion that this appeal should simply be dismissed. There's a further significant error, we say, on the part of the Upper Tribunal in the approach that it then adopted when it went about remaking the decision of the FTT. And that mistake is that in framing the issue before it, the Upper Tribunal found that irrespective of any deficiency with the standard method as a reliable proxy, it should nevertheless continue to apply unless the taxpayer was able to identify an alternative proxy for the use of its VAT-bearing overheads that was more reliable. And the Upper Tribunal's conclusion to that effect can be found in paragraph 126 of its decision, which is page 111 of your bundle. You have that. The Upper Tribunal says the focus of the appeal must therefore be on the proposed method, with the taxpayer bearing the burden of proof to establish that the SMO guarantees a more precise determination than the standard method. The standard method is the lawful and mandated method of apportionment up until the point that it's determined that a proposed method displaces it. In our judgment, the starting point is therefore to consider whether or not the test set out in VWFS is met. If it is, then the standard method is displaced and the SMO applies. If it's not, then the standard method continues to apply. And we contend that in arriving at that conclusion, the Upper Tribunals misconstrued the standard method override legislation that we've looked at in Regulation 107B of the 95 regulations. And if I can, let me take you straight back to Regulation 107B, which is in your first authorities bundle behind tab 4, page 162. Just look again at what it has to say, just omitting immaterial words for the minute. The regulation applies where a taxable person has made an attribution for their longer period according to the standard method, and that attribution differs substantially from one which represents the extent to which the goods or services are used by him, or to be used by him, in making taxable supplies. And we've seen that Regulation 107B2 then tells the taxpayer what to do if that trigger condition set out in Sub-Regulation 1 satisfied. They have to calculate and account for the difference. So the thrust of this regulation is clear. Where it applies, departure from the standard method is mandatory.
Oh, sorry, I've just shut down my computer by mistake.
Oh, sorry.
It's all right, we're back.
The point is, where this regulation applies, then departure from the standard method is mandatory. And the only question posed by the legislation in order to determine whether it applies is, does the standard method reflect the extent to which goods and services are used in making taxable supplies, or is there a problem with it?
Is it? The attribution differs substantially from one, which represents.
Yeah.
So you have to compare the standard method with one. So you take the standard method and you look at an alternative method.
Yeah. But the point though, we always need to come up with an alternative. That feeds into 107.2 to calculate the difference and account for it. But the alternative method is not the only means by which to test the veracity of the standard method as a reliable proxy.
And I agree that's the core of ground 2, but it says you look at whether the attribution differs substantially from another attribution which represents the extent.
Well, the way the legislation works, we say, is there a problem with the standard method? What does an alternative look like? Is the difference substantial?
And in this case, there is an alternative to look at, and you look at whether the difference is substantial.
Well, there is an alternative to look at, but that's not the only material that was before the tribunal, before this court, that goes to the reliability of the standard method. And the point that we make in relation to ground 2 is that the tribunal, the court, shouldn't shut its mind to that other evidence and focus with blinkers on the proposed solution to the problem.
Because you put forward more than one solution, or because even though you put forward one solution, the tribunal had to take into account other possible solutions?
The taxpayer was relying upon one solution before the tribunal, but had identified other possibilities were that solution not to find favour.
Where in 107B, I think I'm troubled a bit by your first step, which is that this all starts with you look at whether there's a problem with the standard method, because I can't see that in 107B1 as being the starting point. The starting point is a factual matter of record. Has the taxable person used the standard method to decide how much input tax they're going to get back? So that's the predicate.
Yeah, tick.
And then the issue is whether that use of the standard method differs substantially from a different method based on use. That's where it's going. It's not saying, have you got a problem with that method? It's saying, is there a substantial difference with a different method based on use, which in this circumstance the taxpayers come up with? And isn't that all building in the idea that you get from the directive that the turnover-based method it's a bit rough and ready, but it is an acceptable method and it is intrinsically fair, But all the CJEU authority tells us that there might be other methods that are fairer. So isn't it starting from an acceptable baseline, but saying there may be better methods around, and that's what you're measuring, is whether you've got a better method than the standard method.
Well, the way, with respect to my lady, the way this legislation works is to say, well, we start with the standard method, but we recognise that that standard method may not be perfect in all situations.
No, but I think where you started was to say there's a problem with the standard method, and I'm not sure I've seen that anywhere in the legislation, nor do I think that that's a reliable assertion or submission, because isn't it built into the standard method that it is a fair and reasonable method? It's just you might be able to go upwards from that floor, you might be able to find something better, but it's not right to approach any discussion about the standard method to say it in and of itself is unfair or disproportionate or has got problems associated with it. See what I mean?
Not that it has, but it may have. And this is what the legislation contemplates here.
Where does it say that? Where does 107B say that?
107B says it in terms of when it's contemplating that the result produced by the standard method may be one which differs substantially from one which represents the economic use of the costs in question.
Yeah, represents, absolutely. But that's, I think this is important because it goes to the very exercise you say that the upper tribunal should have engaged in, is that's a test of whether what you've produced, your other method, is a better method or not.
Yeah, but in order to judge that, we also need to ask the question, well, we first need to ask the question, are there deficiencies with the standard method? Do we even need another method?
But isn't the whole test under 107B the idea that you're looking at this other method to see if it's a better method that better guarantees, or whatever language you want to take from the cases, more accurately represents use-based recovery? That's what 107B is asking you, is what is the quality of this other method? Because we know we've got a standard method that's rough and ready, but it's okay. Is this other method better than that?
Yeah, but to start, to have a... Sorry, my lady, I've just got two notes past me. Would you mind if I just read these before I... Yeah. When we read Regulation 107B, the whole premise of Regulation 107B is that the standard method is not a calculation which is a fair and reasonable proxy for the use of the costs in question. And that's why we're saying, well, is something else then? Is there something else that we can employ that is a fair and reasonable proxy? But what we can't do is, in circumstances where there is a fundamental problem with the method that's been employed, we don't say, well, until we can do better, we allow it to continue. I mean, that's certainly not consistent with the guidance that we see set out in the Volkswagen case.
Why not? Because Volkswagen says you need something that's going to give a more precise determination. Yes. And that means you've got to identify something that gives a more precise determination. And a comparison between standard method and the suggested more precise method is what the exercise is about.
Yeah, but if the suggested more precise method doesn't do the trick, that doesn't undermine the conclusion that there is a problem with the standard method in the first place, and we should do something to try and fix that problem.
Well, I can quite see you might still say it's rough and ready, it's not perfect, but unless you can identify something that gives them a more precise determination, how do you satisfy Volkswagen?
Yeah, there is a need to establish the flaw in the standard method, and there is a need to identify that something can be used in its stead. But at that stage in the investigation, identifying something that can be used in its stead, it would be wrong, we contend, to merely confine the analysis to the solution that's been proposed by one of the parties. And I say one of the parties because the override legislation, there are circumstances where both revenue and taxpayer may be contending that it applies.
So this is a purely procedural point, is it, about what ought to happen if the taxpayer puts forward an overly ambitious alternative and everybody goes, well, that's not going to work. It's sort of what happens next.
Well, there's a prior question. I mean, is there a problem that needs fixing? And that's question one. Is there a problem that needs fixing? Before we get to the question that my lady's just...
Is that right? I mean,
Very difficult to say that.
the question is there a better alternative? It isn't really, is there a problem that needs fixing? It's a question, is there something better? That's what Volkswagen says.
Yeah, but the way the legislation, what the legislation presupposes, is that in circumstances where there is a problem, there must always be something better. This is why
why is that so? I mean, if you have something rough and ready, inevitably it's rough and ready, but that doesn't mean there's anything better.
This is where we rely on the analogy, really, with the standard method override. Because there we'll see that the taxpayers, so the special method override, there we see the taxpayers employed a method. But the legislation doesn't say, oh, by the way, if there's a problem with the method, we revert to the standard method because maybe a bit rough and ready, but it's by definition reasonable. What we do in those circumstances is come up with something else, come up with a solution.
Sorry, Mr. Hitcher, I'm sorry, I'm stuck on that first proposition. I think you're in danger of running against European law, aren't you? Because Articles 173 and 174 of the PVD are mandatory, and they say the deductible proportion shall be made out of the turnover-based method. But there is then a permission to member states to allow something else. So the floor is set by European law at the turnover-based method. That is what the directive tells us is the deductible proportion, and we surely have to take. And that is the proportion which is attributable to taxable transactions. So it's built in, it's baked into the directive that is a fair process unless the member state allows something different to happen. So the predicate is wrong that you say there might be something wrong with the standard method. So that can't be. You may come along and say, I've got something better. That's what the tribunal has to look at.
But with respect, my lady, if we run with that logic, the logic you just explained to me, if we run with that, we arrive at the conclusion that the special method override runs contrary to European law.
No, it doesn't, because it's permitted by 1732C.
No, but you've got to look what the override legislation says. The override legislation says the commissioners can serve a notice saying there's a problem with the method that's been employed.
Yeah.
In circumstances where there's a problem with the method that's been employed, you've got to go and look for an alternative. It doesn't say, oh, apply the standard method until you can come up with something better.
It doesn't have to. I mean, that's all in a discretionary area. And anyway, we're not in the special method, we're in the standard method. Once you get into the special method through a different route, and it may well be that because once you're into special methods, that what you do with a special method, if you're HMRC that doesn't give a result that you think is compatible with use, the remedies may be different there, and you may have to look at a different sequence of actions. But we're in the special method, and you're saying that you get to 107B where there's a problem with the special method, and I just find that really difficult. I'm sucking on a lemon here.
Well, the short one is special method, standard method. If we're in the override legislation, they should work in the same way. But this submission that we start by considering whether there is a deficiency, it isn't something we've just plucked out of thin air. There is some support for this as well in Mr. Justice Warren's judgment in St Helens School. Perhaps I can just take you back to that. You recall St Helens School is behind tab 8. It begins at page 227. He also gave some consideration to the standard method override in that case. Can I ask you to turn to page 250, please?
What paragraph?
Paragraphs 82 and 83.
How does that help us?
Well, it's the last sentence in H2. In other words, he says, the override will apply in the present case if the standard method results in an allocation under the standard method, which differs substantially, etc. And he's posing there the very question we're inviting you to pose. You start by with a consideration of the standard method. Does the standard method produce a result which accords with the principle of use? The way in which he expresses himself in that sentence. And we then go on, so okay, let's look at the...
All he's doing is paraphrasing 107B.
No. Yes.
He's saying the override applies. The standard method results in allocation, which differs substantially from one, which represents the extent to which the sports complex is used, etc. So that's just a lift from 107B, isn't it?
Which is why I didn't understand how we were held.
Let me go back to 107B.
Page 162.
Yeah, thank you. Thank you very much, my lady. Just turning back to it, and the language. It is focusing in the first instance on the standard method attribution, the attribution according to Regulation 101. And then I take the point that Lady Justice Whipple made, that attribution differs substantially from one which. But word one there is an attribution which represents the extent to which goods and services are actually used. But it doesn't have a particular attribution in mind there. In identifying what an alternative may look like, we first of all need to consider or have in mind the deficiencies with the standard method. What is it that that causes it to break down in this case? And once we've answered that question, what is the problem? We can start to come up with a meaningful solution to that problem. But consideration of the problem, stage one of the analysis, is key.
And that's probably going to be a convenient moment.
Thank you very much, Mike.
In which case, 2 o'clock.